Okay. Hello and welcome to this webinar entitled IP for Entrepreneurs. That's intellectual property for entrepreneurs. Just going to share my presentation screen here. My name is Joe Hedzima. I'm a senior lecturer at the MIT Sloan School of Management. I have degrees in undergraduate and master's degrees from MIT. And a law degree from Harvard. I've been involved in the starting of over 100 companies, primarily high-tech companies. And I've been asked to give a talk to entrepreneurs about the role of intellectual property and how they should approach it. My presentation is focused mostly on US law. The law for IP varies country by country, although there are several themes that are consistent. And as you can see from the slide, this is for background education only, in the sense that legal matters are very fact-specific, so you shouldn't, excuse me, I'm having notices on my computer here. Legal advice is very fact-specific. So you should take this as a overview from a business perspective and perhaps to put you in a position to be able to have a discussion with your legal counsel in a more educated way. So with that, let me move to the next slide. The topics here that we're going to cover today are 5. We're going to talk a little bit about what the value of intellectual property is. Why should you care? The different types of IP, a little bit about IP strategy, how to think about dealing with intellectual property, and then patent basics in the US on the assumption that some of you may eventually come to the US and certainly would want to know about the US patent system, which is one of the most advanced in the world, and then some practical advice on how to deal with all this as an entrepreneur. So the question I would put to all of you is, what is the entrepreneur's primary job? And when I ask people that, there are a whole range of answers that come that include developing a product, innovating, and doing this and that. Those are all the specific steps. But I think the primary job that I would like you to think about is your job is to create and capture value. If what you're doing doesn't create value, then you don't have a business, you don't have a sustainable, you don't have a venture. And yet if you create value and you can't capture some of that value, then you don't have a sustainable business or a sustainable venture. And so I think the primary job is to think about, how do I create value and how do I capture some of that value in order to do it again. In the area of intellectual property, we have to look at what's happening in the overall market. This graph is an interesting, quite dramatic graph going from 1975 to 2015. And it says for the S&P, the Standard & Poor's 500 market value, that is the stock market value of those 500 largest companies, what percentage of that market value is composed of intangibles? And as you can see, in 1975, it was 17%. And by 2015, it was 84%. Now, intangibles here are, if I take the stock market price, the total price of the stock times the number of shares, and I subtract from that the tangibles, that is the real estate, the equipment, the things you can touch and feel, what's left over? And in 2015, 84% of the value was stuff you really couldn't, quote, touch. These are called intangibles, and they include everything from brand recognition, to people, and the intellectual capital of the people. And some portion of that intellectual capital can become intellectual property, that is, something that is legally protected that you can deal with. And so when we look at large companies, and this is consistent across most of the marketplace, if you think 200 years ago, value for industrialized countries was basically, we were agrarian, So it was in land ownership. In the Industrial Revolution, it became value or wealth was a function of equipment and property and factories. And today, it's more about ideas and innovation. So anyway, with that background, when we talk about how do we create value, let's look at what large companies do and what emerging companies. Most of you on this webinar will be emerging company side, I would think. Large companies, though, are really not designed to innovate. Their main job is to execute a business model that they understand. They strive for predictability of results, and they operate at scale, and they try to maximize economy of scale to improve profitability. That's not to say they don't have research and development, and they don't look around for opportunities. In fact, many large companies are beginning to understand, have begun in the last 10 years to understand that innovation is likely to come from outside of the large companies. If we look at emerging companies, we're all about innovation. It's about, finding a viable business model. It's about speed and iteration as we try to do that. And so how do these two things bridge? And here's where large companies are looking to acquire de-risked innovation that emerging companies are able to prove. That is something that's technologically works. There's some indication of customer acceptance. And in a sense, you can think of venture capital that supports emerging company as a form of outsourced R&D, research and development. And it works sort of this way. If a large company undertakes a new innovation process and they have to do research and development, the costs of that are expenses that are subtracted from their revenue and decrease profitability. And they don't work quite as fast as small companies. On the other hand, if a large company acquires a smaller company, they're acquiring an asset. And that goes on the balance sheet, and it does not impact negatively the earning, by and large, the profit and loss. And so large companies are willing to pay a premium for emerging companies that can show that they have developed innovation that can be taken by the large companies and put through their sales and marketing and manufacturing processes. So it's an interesting system where these two coexist. So if we look at the S&P 500 percentage of market cap that's intangibles, and we look at this slide relating to large companies, if you're in emerging companies, one of the things you need to think about is how am I creating value with intellectual property? Because that's a large portion of what the large companies have. So it's important to the large companies. So with that background of talking about the value of IP, how can intellectual property help your venture? Well, first of all, as we've shown, it's a valuable asset. If you develop it thoughtfully, you can use it to raise capital. And many venture capitalists, I was in a talk yesterday where we discussed the difference between institutional venture capital, that is people that are financial players, and corporate venture capital, and what the role of IP was. And certainly for institutional venture capital, the fact is they want to know if you have some intellectual property. They may not have an ability to assess it, but they're going to want to think that you know what you're doing there. And when you have intellectual property, you've developed property properly and thoughtfully, it can help increase your value to acquirers. And in fact, there is some evidence of this. The company that I co-founded, IP Vision, was at one point, we were a venture partner in a late stage venture fund. This would be a fund that made the last round of investments before a public offering or an acquisition. And we ran patent analytics that we developed over venture-backed companies to help that venture fund determine which ones they want to invest in from earlier stage venture capital. And using just publicly available data, we had analyzed some 9,000 of these venture capital-backed companies. And those that scored in the top quarter of our ratings, based on public data, 85% of them were winners in the sense that they had gone public, had been acquired, which is an incredibly high percentage. What it is, I think, is we were looking at, how well developed was the IP, how well managed was it, and that's probably a surrogate for good management in general, and therefore well-managed companies are likely to be winners versus those that are not well managed. But there is correlation there with IP and success, financial success. And you can also, as part of your acquisition strategy, and I should have pointed out on that slide with the large company, emerging companies, that most of the venture-backed companies that succeed are acquired. The vast majority of them are acquired. So that doesn't mean that your company has to go down that route. In fact, you don't even need venture capital. But if you're going that way, then you want to be thinking about, am I telling a good story about my idea, my innovation, the market I'm addressing, and am I a good manager? And so we'll talk a little bit more about the strategy part as we go through this. So with that background, what are the different types of intellectual property protection? And I've listed a number on the screen here. None is, of course, no protection. You haven't done anything. But sort of the first level is trade secret. That is, you have an idea and you keep it secret enough. That might be a manufacturing technique or some way of doing something. And that basically can prevent others from doing it because they don't know the secret. So that can be very powerful in the right circumstance. Trademark, which relates to the ways in which customers think about your company and product. We'll talk about that in a moment. And copyright, which relates to whether people can copy or use things that you write or design. Those two can enhance value, but they don't block others. In other words, Coca-Cola or Coke is a trademark, and it protects other people from selling a product called Coca-Cola, but it doesn't prevent Pepsi from coming along with a very similar product and trying to address the same market. So it can enhance value. It doesn't block others from doing the same thing. It can keep them from using your brand. And finally, patents, which we'll talk about extensively here, cuts both ways. A patent, as we'll talk about, is a limited time monopoly granted to the owner of the patent to prevent others from using the invention. But in order for a person to get a patent, they have to disclose their invention. And the reason I say it cuts both ways is once you disclose your invention, it means other people can learn from it. And when your patent expires, they can use that invention, or they can take the ideas in your invention and perhaps it gives them some ideas. So it cuts both ways. And we'll deal with that in more detail. But let's look at another dimension to this. By the way, combinations of protection are available. So for example, software in the right circumstances can be protected by both patents and copyright. So if we look at duration, that is, how long does this protection last? A trade secret could last indefinitely if it doesn't get disclosed. On the other hand, patents in the US anyway have a life of 20 years from the date you file the patent. And the others are somewhat in between. And when we go about costs, though, it goes the other way, because trade secret can essentially cost you nothing. You just have to maintain your trade secret by not disclosing it. And as we'll talk about, patents can be very expensive. So that's sort of the overview of IP protection. Let's dig down into it a little bit. Trademarks and service marks. This is where you develop a name for yourself. A trademark is a name, a word, logo, sound, color, that when people hear about it, they think of you. So if I say Mercedes-Benz, you think of a luxury automobile. If, in fact, sound has been trademarked, the the sound of a Harley Davidson motorcycle is actually a trademark. So if you were to try to replicate that sound and selling a different type of motorcycle, you would be infringing the trademark of Harley Davidson. There are, in the US, the rights to trademark. By the way, service mark is the same kind of thing relating to a service. So trademark is for products, service marks are for services. The rights arise under US law from use in commerce. That is, if you use a name, a symbol, or whatever in commerce, then you can claim a trademark. That's where you put the little TM next to the term. If you register it in the US with the US federal government, you can put an R in the circle. And when you pick a mark, you should think of something fanciful that's not easily connected with your product, and you build the brand. So, for example, the idea of naming a computer an Apple computer is odd, or perhaps Nest for a thermostat. Those are fanciful marks. They're stronger once they're established. If you pick things that are merely descriptive, you may not even be able to get a mark. So companies like Storage Technology, they store things, so that's not a very strong mark. Analog Devices is a very engineering advanced company in the Boston area, and they make analog devices. So those are not strong marks. You can ask, is a mark available? In the United States anyway, you can go to the US Patent and Trademark Office and search their trademark database to see if somebody has registered it. I did say that trademarks arise from use in commerce. In the last 10 or 15 years, what used to happen is you'd have to use it in commerce, do the advertising and all of that, and then file for a mark and hope you get it registered. Now there's a procedure in the US called intent to use, where you file with the federal government and you say, I intend to use this mark for these goods and services. Then you sort of reserve it. And then you can go out, and as you develop it and actually your marketing materials and everything and get into the market, then you file something that says, well, I've actually used it now. So you sort of reserve the mark without having to take the risk that somebody's going to get it before you. So that's trademark, service mark. There was a question that came up before the webinar. I'm going to back up to the slide on IP protection. All of these protections are national. That is, each country has laws relating to this. So if I have a trademark in the United States, that doesn't automatically protect my product in Japan or Germany or India. I have to file for trademark in country by country. Same thing with patents. And that can get, all of this can take a bit of effort, but it's a country by country thing. Now there are treaties in each of these areas that allow filings in one country to sort of preserve rights for you to then file in other countries. We'll talk about that a bit, but we'll talk more about patents, but it's country by country. So we talked about trademark and service mark. Let's look at copyright. This is the right to make copies. In the United States, if I write a letter to my mother, that's an original work of authorship, and I own a copyright in that. I don't actually have to register it anywhere, although in the US registering it is required if you intend to sue for infringement. Copyright protects the expression of an idea. It doesn't protect the idea itself. So, and the reason is we want to encourage expression. So if Shakespeare writes a play, Romeo and Juliet, and could prevent anyone else from writing a play about a love relationship, that would certainly diminish the vitality of literature, and therefore you can't copyright that idea. You could copyright the actual words and the scenes and other things, so that somebody else couldn't come along and simply copy a Shakespeare's work. Copyright is good for music, it's maybe a poor fit for software. We'll check about that. At least in the US, the important thing as an entrepreneur to understand is who actually owns the copyright. And the copyright is owned by the author, the person that writes it. This could be. And unless that person is an employee and who creates that work of authorship during the course of employment. So if I employ you as a software engineer for network analysis and the stuff you write there is owned by me as an employer. But if in your spare time you're doing a video game that's not related at all to my company, then you own it. The other case where the author would not own it is if it's a work for hire, which is a specific contractual arrangement in which the person who writes the author agrees that the person that paid them will own that right. And it typically comes up in the case of consultants. So a number of years ago, back when I was practicing law actively, I had a client who was in import-export, and they had contracted with a third-party manufacturer to develop, sorry, I'm getting these notices here. They had contracted with a third-party developer to develop a computer system to assist them in import-export record keeping and the like. And they spent over $500,000 for that. And one day they called me and said, the people that wrote the code for us are now selling it to our competitors. You have to stop them. And it turned out that they had not entered into an agreement with the third-party computer software company declaring who would own it. And so, in fact, they could sell it. So in the US, often we don't hire employees right away if we're doing something at early stage. So I'm involved now in a company where we have 6 independent contractors, not employees, who are working on specific parts of an overall project. And these work will take anywhere from 3 to 9 months, so we're not hiring them for full-time employee. But we do have contracts with everybody about who's going to own the work. And finally, in the software area, you have to check for open source issues. You can incorporate open source code into your product under the general licenses there, and you want to make sure that you carefully follow that, because when the time comes for you to be acquired, or even maybe for financing sources who don't really want to buy into a lawsuit or whatever, they're going to want to see that you've complied with all of that and there's not a problem. So that's copyright. Trade secret, again, this is secrets you use that give you an advantage in the marketplace. Probably the most famous example is the formula for Coca-Cola, which supposedly is still secret, and it's not easy to reverse engineer. In the US, the protection for trade secrets varies from state to state. In the US, we have 50 states, and those 50 states comprise the United States. So each state is a separate governmental thing, and the federal government is on top. There are uniform laws in the United States. That's where the lawyers have gotten together and said, this is sort of a uniform way of approaching things. Each state then adopts those with some variations. So you have to check to make sure if you're in California, your trade secret rules are different than Massachusetts. Trade secrets last as long as you keep it secret. And that's why it's important either not to disclose it, or if you do disclose something, you do it under a non-disclosure agreement, a written agreement with the person with whom you're sharing your information. For those of you raising money, don't put your trade secrets in any business plan or pitch deck. If it requires disclosure of your trade secret to get along in the financing process, then you're not approaching it correctly. In the financing process, you want to talk about the benefits of what your product or service does. You don't have to tell, at the beginning anyway, what the actual way in which you do it at a level that discloses your trade secret. I would say in the United States, venture capitalists most likely will not sign non-disclosure agreements. for a practical reason. That is, you may think your idea is unique, but I can guarantee you there's someone else doing something similar. These things come in waves, and they don't want to be, venture capitalists don't want to be accused of stealing your idea. And so they'll say, we're not signing a non-disclosure agreement. You decide what you're gonna tell us. And then finally, patents, which is the most complex but the strongest protection. Let's talk about that. Again, country by country. In the United States, it's granted by the federal government for any system or method that is new, non-obvious, and useful. It has to be applied for and issued. It's granted again by the Patent Office, country by country. It's very much like real estate. The fundamental right when you own real estate is to keep trespassers off, to keep people off your property. That doesn't mean that actually, and by this I mean it prevents others from making, using, selling, or distributing the patented invention. So for example, if I have a patent on a coffee cup in the United States, I can prevent you from making it or selling a similar thing in the United States. If I don't have a patent in China, you can go to China and make coffee cups there and sell them there. But if you try to bring those coffee cups into the US, I can prevent you from doing that. So it's a right to prevent somebody from doing something. It doesn't necessarily mean you have the right to use that. Now, what do I mean by that? Think of real estate. You may have a piece of property that is surrounded by other pieces of property. And if you have to walk across someone else's land to get to your land, those other people can prevent you. So it doesn't mean you can necessarily use it. The claims of a patent, I'll come back to that idea of right to use on the next slide. The claims of the patent are like the fence around the property. They describe what the property is that you can prevent people from using. And in the United States, the duration of a patent, a utility patent, which is the most typical patent, is 20 years from the date you file that application with the Patent Office. There are design patents, and that's 14 years from the date the patent issued. Those are very specific. Let's illustrate this right to prevent others from doing things with a simple example. Let's say you patent a vessel to hold a liquid, and you got that patent because nobody ever thought about that idea. It's truly unique, it's clearly useful, and you get a patent on that. And I look at that and I say, gee, that would be a better product if I could hold it easier. So I patent a handle. So you have a vessel to hold a liquid, a cup, and I have a handle. There's no way that I can put my handle on your cup, or you can put your cup on my handle, unless we both agree. That is, each of us has the right to exclude the other from using our invention. And so unless we can cross-license each other, there's not going to be a handle on a cup, or there will be litigation. I think this is a good way of thinking about that. So in the US, the requirements to obtain a patent specifically are it has to be something new, novel. And in the US, you're required to tell the Patent Office about, quote, prior art, which is a way of saying things that are out there already that are relevant to show that what you're claiming is new. And I'm going to show you how we use that prior art citations, as we call it, to help understand the patent world on a slide that's going to come up here. So it has to be something new. It has to be useful. That's usually not a problem. And in the US, it has to be what's called patentable subject matter. It's a process, machine, manufacture, or combination of matter, or any new and useful improvement thereof. There's been a number of court cases in the last 5-10 years in the US trying to define the scope of what subject matter can be patented, including computer algorithms. This will get itself sorted out at some point. And all these things you're going to want to talk to a patent lawyer about when it comes time to decide whether you want to do something. All right, so it has to be novel, new, it has to be useful, it has to be something that can be patented. For example, something that cannot be patented is like a method of accounting. Clearly can't be patented, although machine to do that could be, perhaps. So it also has to be something that you have not previously sold or publicly described. This would be an enabling disclosure. So if I say to you, I've invented anti-gravity boots, and I don't tell you how I do it, that's really not enabling. An enabling disclosure doesn't tell you how to do it. So that would not be a bar to my getting a patent. And in most countries in the world, I would venture to say every country except the United States, if you sell something or publicly describe your invention before you file in the local patent office, then you will not be able to obtain a patent. Again, very important. I was dealing with a group from Egypt, very proud about their technology to increase the throughput of wireless networks by 10 times. This is at a conference in Istanbul. And I asked them if they had filed a patent application. And they said, no, they were thinking about it. And I said, well, have you published anything? Oh, very proud. They said, we've got a paper in a prestigious journal. And I said, oops, depending on what that paper says, you may not be able to get a patent anywhere in the world except possibly the United States. Now, the rule in the United States is you have a 1-year time period from the date that you publicly disclose or sell something, 1 year in order to get an application on file in the patent office. If you do that, you could get a patent in the US, but you will not be able to file anywhere else in the world. So it was very sad to see these people who were so proud about their accomplishments trip over this relatively simple rule because they didn't know about that. So again, important takeaway, don't disclose publicly what you're doing if you intend to patent it until you've actually filed something. And then the next thing is, requirement is the invention can't be something that's obvious. If it's not obvious to one of ordinary skill in the art, then that's something you could patent. But if everybody else, if I went to people in your field and said, what about this? And everyone say, oh, gee, that's sort of obvious. That might be a bar to your patent. And there are ways of overcoming that, which you'll talk to your lawyer about. In the United States, we recently moved to the system that I think is around in most countries of the world, which is the first inventor to file is the one that wins. So if you come up with an invention today, and I come up with the same invention, not knowing about what you've done next month, and I put a patent application on file in the US and in most countries right away, and you end up filing the same invention, say 3 or 4 months from now, I'll end up winning. So it's very important to be diligent, first inventor to file. So that's sort of some basics about that. Let's talk about strategy now. We've got all these different these forms of IP. Which ones are valuable to you? What are you trying to protect? Do you have core technology? Then you might think of patenting. If you have a product, if you disclose how you do it in a patent, is there a possibility of somebody engineering around it? Is the lifetime of the product or service long or short? If it's an app for a mobile device, that may be a very short time frame. Will it be something that's profitable over time that means that it's worth spending the money to patent it? And what's your business model? Are you going to manufacture and sell the product? In which case, maybe you keep things trade secrets so no one knows how you do it. On the other hand, if you plan to license or partner or be acquired, you might need to have some strong IP protection so that the person who licenses from you or acquires you can use that as a barrier to prevent others from coming into the market that they've not bought your company to address. There may be non-intellectual property bars to market entry. That means you might not have to worry about it too much. There might be regulatory things or economic aspects that, depending on the industry. For example, in the US, you have to have a drug approved by the Food and Drug Administration, and it doesn't have to be patented. But typically it is, and we do know the combination of an FDA approval for the drug plus the patent keeps the price high, allowed to be high. And when the drug goes off patent, there tends to be a bunch of companies coming in, the generics are called, who can make the same thing much cheaper, and you see the stock price fall for a company. And then finally, do you have an exit strategy that may inform how you want to proceed on an IP basis? I'm going to skip this slide for a moment. It'll be in the deck. Let's move on to before you launch something. Typically, well, let me back up to that one. I apologize. So, as a new venture, you want to think about: do you have the freedom to make, license, or sell your product or service? Are you going to infringe anybody else? Can you actually do it? You have to ask, does your company own the technology? Did the inventor, in the US, and I think in most countries, the inventor owns the patent. Typically in the US, that's assigned, if the inventor is an employee, it's assigned to the employer, and therefore the employer or the company owns it. In the US, often we license from universities, so do we have the rights there? And of course, did it go in the public domain through disclosure? All informs what strategy we're going to have. So let's start with the look before you launch, the freedom to operate. Is someone else's intellectual property actually going to prevent you ultimately from going into the market? Investors are going to worry about this. You should worry about it. And it's typical to get a freedom to operate opinion in the United States from a patent lawyer because it informs you somewhat about whether someone else is out there. And then if you do happen to infringe without knowing about it, by having an opinion from a lawyer saying you're free to operate, prevents you from being hit with triple damages, which is available. But I think you also need to understand this from a business perspective. What is the IP space around your technology, your product? And who else is there? Are they competitors? Are they possibly partners? Those are the kind of things, for example, my company, IP Vision, does. Helps people make those kind of make or buy decisions. The failure to look before you launch can be fatal. You may not get an essential license you need. All your time and effort may be wasted because somebody doesn't want to allow you in the market. And investors are going to run away if any sign of any lawsuit. The last time I checked, the average price of a patent lawsuit in the United States ran between $3 and $5 million. And if you follow things like the Apple, Samsung litigation that's been going on around the world, we're talking hundreds of millions of dollars. So not something investors want to get involved with. So how do you determine whether freedom to operate? Well, you can do a search. There are many different places to do it. You can go to a lawyer. One of the benefits you get from this webinar is you can use the website that my company has put out there. We have a free version and a paid version. It's See the Forest. It's there. You see it on the screen. For entrepreneurs, where I've given talks, we provide a free upgrade for 6 or 9 months to a higher version of it. And I'll show you a little bit of what these patent maps that are shown below. So if you email me at service@ipvisioninc.com, and in the subject line you say Joe upgrade, I'll tell you about how you can get an upgrade to this for free. But what is this thing? We do patent maps. It came from a partner of mine, a former MIT computer science and management professor, and I were doing an early stage tech commercialization out of MIT primarily. And we do the things we now teach in entrepreneurship class. And when we got, because it was technology based, when we got to intellectual property, we put that analysis to the back end of the process because it was so expensive and painful. And we got burned a few times on that. And my co-founder, who, while he was an MIT professor, had been the chief outside architect consultant for IBM for the PC-AT personal computer, the first business personal computer. and had taken one of his students, Mitch Kapor, to IBM and said, you really ought to get this software, this spreadsheet software Mitch has. And IBM said, well, we're a hardware company. Mitch told me he would have licensed IBM exclusively for $1 million. He went on to found Lotus Development Corporation, which came out with Lotus 1-2-3, among other things. And IBM bought the company 10 years later for $3 billion. So timing is everything. He came up with this idea of mapping patents. So what is this? This is a patent map. The horizontal axis, the x-axis, is time. Each of these boxes is a patent or patent application. In the upper right corner here, we've got a little example of that. The left edge of the box is the issue date of the patent, or the filing date, depending if it's an application. If it's a patent, I'm sorry, the publication date if it's an application. The tail is when it was filed. These are all based on US data only. In the box there are some information, including some numbers. This says 32,1. This means 32 patents were cited by this inventor as prior art. Remember when I said you have to show that your idea is novel? Those are citations of either literature or patents, and they're very important because if in the United States, if you as an inventor fail to cite prior art of which you're aware, it can be basis for invalidation of the patent and litigation. It's deemed to be fraud in the patent office. And so these things really do matter. And what we do is we take advantage of that fact by having the lines showing that this patent cites this patent over here. So Virtual Ink is a company that I use in my Nuts and Bolts and New Ventures class at MIT. You can check that out at nutsandbolts.mit.edu. And when they first issued their patent, they cited 41, where is it here? Yeah, 40 other patents as prior art. And these are all the patents they cited. And so very quickly, by looking at who owns them and looking at the titles, you can begin to understand what the space looks like. You can do these maps by doing keyword searches or putting in company names and seeing what they look like. Interestingly enough, a few years later, this map in the bottom right that I'm going to bring up shows that patent. And after that patent was issued, there were other patents that came and cited it. So you begin to see the whole immediate patent citation landscape around it. Using these techniques, you can begin to understand not only are there freedom to operate issues, but what other people are in the market. How does that affect where I'm going to enter the market and what kind of products I'm going to do. So take a look at it and hopefully you'll find it useful. So let's switch now to sort of some mechanics around obtaining a patent in the US, determining what to patent, determining when to file, preparing applications, and prosecuting. What to patent is probably the most important step. There's a tendency, especially among technology people, to want to patent any interesting thing that they've done. And so you shouldn't really ask, could I get a patent on this? You should really ask, is this something that's valuable? Does this help me create value? Will this help me capture value from an acquisition? And how would my competitors use my technology if I didn't patent it? And so those are business level discussions. And so don't rush immediately to say, oh great, I could get a patent on this, put it on the wall or whatever. Ask, does it help me create value? Because remember, that's what you're supposed to be doing, creating and capturing value. You should file, of course, in the US before you lose US or foreign rights. Now, there is a patent cooperation treaty, which most countries in the world are signatories to. And it's a little complex, but essentially if I file a patent application in the US and I file and designate it as a PCT, a patent cooperation treaty filing, and I can then have that treated as an application for all the countries in the world in which I want to file or potentially file, and I designate that on the form. So that's how you preserve rights. In the US, as I said, we switched to a first inventor to file, so being diligent about this is now important. And of course, you want to make sure you get it filed before you put the product or service out in the market. An important advance in the US in the last 10 years, remember I said that in the US you have 1 year from the date of disclosure to get a patent application on file, but that actually is a problem for the rest of the world. They came up with a thing called a provisional patent application, which is treated, I believe, most countries in the world as a filing. And why it's important for entrepreneurs is you can make a filing, a provisional. It can be done quickly, and it's cheap. You see there it's $70 filing fee in the US. It does not have to have claims in it. It simply requires a meaningful description of the invention. It establishes your filing date priority. And what it does is it gives you 1 year in the US in order to get what's called a utility patent on file. So if you file a provisional, you have 12 months to get the full filing on it. This gives you time to go out and know that your idea is potentially protected, and to start talking to people about it and decide whether there's commercial interest in it. Nothing happens at the patent office. It's not published. It doesn't become public, so it can be done very effectively. Now, the lawyers will say, well, you really should do a full utility application, you know, with bells and whistles. And sure, if you have unlimited time and money, it's always better to do that. But most of us have to make trade-offs on how much things cost, etc. And time is important for our inventors who are developing the products, etc. So provisional is something I've used where we, in IP Vision, the map that I showed you, we were a software as a service, and we would come up with new releases every 4 to 6 weeks. And before we release something, we'd have a meeting and saying, but what did we do that we think is commercially valuable that we might want to file a patent application on? What did we think about doing but did not implement that came up? And then we would file a provisional patent application. You know, and we did like 6 or 7 of these over the course of a year, basically maintaining an option for us to file a full application. And so it's very effective. And eventually, within a year, we had to then, decide whether we were going to invest the additional money, but we had more information at that point. One of the drawbacks of provisionals is you've got to make sure that your description at the beginning is broad enough. So if I say, let's say nobody had ever determined that fruits and vegetables were good for you, and I made this wonderful discovery about how to make them healthy and process them or something. And in the course of the year, I file a provisional on that. In the course of the year, I also determined that protein, meat, is important. Well, I can't add that into my full patent application and get the earlier date because I didn't talk about it back then. So I would have to file it. It would only go to the date that I filed a provisional around the use of protein. So there is a risk that if you're not broad enough, that you're not going to be able to get that priority. But I think that's worth the effort in most cases. I've even seen people take papers they're going to give at a technical conference and put a cover page on it and send it to the patent office in order to maintain rights. So provisionals are very good for entrepreneurs. If you haven't seen a patent, it's like a term paper. It describes the field of the invention. There's a background part that says, what is it out there that I find needs fixing? What's broken and how do I fix it? And what's the advantages that I have over what's there before? And I'm supposed to, in the US, give the best mode of practicing my invention. It doesn't have to be what you ultimately do, but at the time you go through the patent process, what's the best way of doing this? And again, that's part of the bargain that says we'll give you a limited time monopoly if you disclose your invention. And then finally, the claims. What exactly is your invention? What is it you're going to end up protecting? Patent costs in the US, the legal fees are anywhere from 5 to 15,000 for a lawyer to prepare. You've got to manage the process. I'll give you some hints on that at the end of the talk. I had, knowing this, I had my co-founder was busy talking to the lawyer and not telling me, and we ended up with a $35,000 bill. So you've got to control that process. Filing fee in the US is modest, at least, depending on the size, whether you're large, medium, or small. And once it's in the patent office, it's hard to predict what it's going to cost, but you should think about it costing a minimum of $5,000 to $15,000+ in the US patent office. It's not fees you pay to the patent office, it's the fees you pay to your lawyer who has to deal with the patent office and the objections, etc. And that's a little bit, that's why even once it's filed, you got to decide, am I getting anywhere? Is this worth the money? International patent fees vary country by country, can be very expensive. At the bottom of this slide, there's a statement, the Government Accounting Office study, that's a government accounting office in the US, looked at a small company, for example, and a series of patents. And if a patent were filed in 10 industrialized countries, what would it cost a small company over the life of the patent? And this was in the early 2000s, like 2003 or 4. And the conclusion was anywhere from $300,000 to $500,000. That includes the lawyer's fees, the initial filing fees. You have to maintain the patent by filing periodically. In the US at 3.5, 7.5, and 11.5 years. Many countries, it's sort of a yearly or monthly even filing, I think, in some. So if you add all that up, it ranges from $300,000 to $500,000, some 15 years ago. So they're expensive. So you don't want to necessarily file everything. But I think the combination of, if you go back to the original slide about creating value and capturing value, if you're building a company that you think the exit is likely to be an acquisition, you need to be telling a story both about your ideas, your market, your customer acceptance, and the fact that you've got these patent applications pending out there. I just signed up a deal in last June with a major consumer products company in the United States for a company that I co-founded. And fortunately, we had a bunch of applications, we planned a bunch of applications on file from a couple of years ago. And the week before we finally signed the deal, we got notified that one of our patents had issued in the United States, in Europe, and in China. And that made a big difference in getting that deal done on terms that we found acceptable. Because for the large company, they knew at least there would be a patent out there. Before it was, okay, you've got all these applications, but how do I know what happens if they don't issue? And we just took that off the table. The timing was wonderful, but we did have the optionality there so they could continue to prosecute them. Now, because patents are expensive, we need to think about, is there another way to deal with IP? And there's two sides of this. One is avoid being picket fenced, I call it. So a fence around your property. The picket fence is a group of patents that surround a patent for the purpose of blocking the commercial implementation. So for example, let's go back to the vessel to hold a liquid. I might come along and say, hey, I could put a cap on that, and that would make it commercially interesting. I could put a sleeve on it. I could put a handle on it, and maybe I make it out of insulating material. And I might go or somebody or a group of people might end up filing all those patent applications and getting patents on that. And what effect we would have done would be steal the value of some of the value of your invention, because you can't really do the things you need to get to the commercial implementation. You just have a vessel to hold a liquid. And you do not want to be in that position. It's like a problem. So how do you prevent that? Well, one of the things I mentioned is you have to, in order for someone to get a patent on the cap or the sleeve or the handle or whatever, they have to show that it's not been done before or nobody's disclosed that. So one way to prevent you from getting picket fenced is to actually disclose that. If you believe, in talking to your patent lawyer and doing your prior art searches, that you have a core invention that's really strong and you can get a good patent on it, and you don't have the money to spend on all these side patents, then simply disclose it. Say, my vessel is great, and you could do lots of things with it. You could put a cap on it, you could put a sleeve on it to insulate your hand, you could put a handle, you can make it out of all sorts of materials. And then once you've disclosed that, nobody else can claim those things as their invention because, hey, you told them. And so that's can be a very effective thing if you've got a core technology and you and your lawyer figure out that this can get a really strong patent on. An example, using an IP Vision patent map of a picket fence. This is a landscape patent map of a patent from Ring. Ring is a company in the US that sells video doorbells, internet-controlled video doorbells from your mobile device. You can see who's at the front door. Well, when we did a patent map of this and said, well, who's citing this patent, there are a bunch of red boxes on this map. It turns out these are all patents filed by Skybell, which is a competitor. And so they filed a whole bunch of implementations around this. And you can just see visually there, even without reading it, there's a lot going on there that potentially blocks Ring. Now, it turns out Ring, through other reasons, got acquired for a hefty price, but I don't think the story's over on the patent litigation that may come from this. Anyway, the message here is avoid the picket fence. So practical advice, sort of wrapping up here. What can you do? Well, with your employees, you want to have invention disclosure and assignment agreements for people that are your inventors, saying they're going to disclose what they've done and will agree to assign that invention to you as an employer. Typically, these also require the employee to say what inventions they've had before, maybe from another company, so you don't infringe. If you're using consultants, you want a consultant agreement specifying that the work is going to be a work for hire and it's going to be owned by you, the company that employed the consultant. You may want to use non-disclosure agreements where appropriate to preserve your rights. You want to avoid infringement. You want to keep an idea, look at freedom to operate and must continue to understand the patent landscape. You can do that with our Aceva Forest thing, run it. Maps every week you could, because patents in the US come out weekly. And you want to try to preserve patent rights in the most cost-effective way you can, using things like provisional patent applications, and make sure that you get all those applications on file as soon as possible because of the first inventor to file, and make sure you don't disclose stuff before you file. And then you want to think about avoiding the picket fence problem. And all of that together is a story that you can tell about, help you tell a story about the value you've created and how you're going to capture that. That'll make you more valuable. And then finally, how do you deal with lawyers? Well, you're typically buying expertise by the hour, and so you want to be very disciplined, not only for IP, but for other reasons. It's perfectly okay to go to a patent lawyer and say, here's my lab notebook, write me a patent. It's going to cost you a lot of money. If you're thinking about patenting, you should read some patents in your space. You should spend some time drafting, not the claims necessarily, but a description of what it is. What is the problem that you saw that caused you to make this invention? And write something that's detailed enough that the lawyer can take and then spend the expertise in the claims. The claims is what you really want the expertise at. And that way you can streamline the whole process. And don't wait until the absolute last moment. If you file a provisional and you decide you're going to go and file a utility patent, don't wait until 2 weeks before the year runs out, because first of all, the lawyer is busy, won't get their full attention, their job, they may not do as good a job, and they're going to charge you a lot. If you're thinking of patenting it, give them some advance notice so they can get it on the calendar, so to speak. And someone reminded me that I have a good thing called 10 Commandments of How to Work Effectively with Lawyers. You can see that on the nutsandbolts.mit.edu website, or if you get a copy of this deck, that link will take you there. So what we've covered is the value of intellectual property, the types of IP, some IP strategies, some patent basics, some practical advice. I hope you found that useful. You can contact me by email at either of these addresses, and I wish you luck in your ventures. I don't know if we have time for any questions. I'll leave that open to anyone. Otherwise, I will sign off and wish you a good adventure in your ventures. Okay, no questions, then enjoy the rest of your day.